It is probably just a huge coincidence, but when I had returned to the Shenandoah Valley a little over 2 decades ago, there were only two major blockbuster movies, and I love movies, that I simply had to see. One was Deep Impact, a big disaster film foreboding global catastrophe, with an A-list cast that included Ty Leone, Elijah Wood, and Morgan Freeman, which I only wanted to see because I was actually an extra in the movie. In the exciting end of the world scene, joining probably about 1,000 other motorists on an abandoned highway strip in Manassas. And if you were to go on Netflix tonight or sometime in the future, you'd have a better chance of seeing the interior of my Jeep Wrangler, which appears in the scene near the beginning with the discovery of the meteor and the scientist on a collision course with the planet Earth has an automobile accident and drives off into a canyon. Then seeing the brief scene where I am actually standing in my Jeep watching the meteorite pass over on its way to splash down in the ocean. But the other film was another A-list cast blockbuster based upon a John Grisham novel, which we all love, and starring Matt Damon, Mickey Rourke, and Danny DeVito, called The Rainmaker, about a new law school grad named Rudy Baylor, who hadn't even yet passed the bar exam before he had been hired to work for a colorful character named Bruiser, and had taken on a case against the big insurance companies. Probably like most first-year law students, especially at a Tier 1 law school, like I had just entered after departing active duty, I had mixed feelings about the Matt Damon character, identifying with his passion for justice and sense of compassion, like we like to believe all people go to law school to do, but already jaded in law school enough to recognize that if the kid was such a great attorney, he wouldn't be working for a small-town ambulance chaser character like Bruiser. But years later, I have a new perspective, that Rudy Baylor could not have taken a case like he did unless he happened to work for a fugitive deplorable like a character named Bruiser. And now, looking back on those scenes in a film provides a better perspective regarding the current dilemma faced by some persons with regard to the COVID-19 vaccines. Hello, my name is Major Mike Webb, and at the outset, let's commence with the standard disclosure by stating again that I am not an attorney, nor is this to be considered legal advice. But I can confess that I did a little more than just watch an attorney on TV. And immediately after the celebrations for Independence Day, we actually took a little road trip down to Richmond to file with the Federal District Court what will amount to our third litigation during the current public health crisis, an action that included at least one count against the governor and state attorney general under the federal racketeering statute, RICO, for their willful evasion of a summons being served by the sheriff first for the city of Alexandria, and second, the United States Marshal, in the first filed and longest surviving litigation challenges to both the lockdowns and the facial coverings mandates. Any history buff probably knows that evasion of a summons is actually how the FBI managed to apprehend the untouchable Al Capone, and not exactly the way that you may recall from the blockbuster movie with Kevin Costner. The tax evasion case that sent the crime boss to Alcatraz Island was actually built while he sat in a prison cell after being apprehended in Miami, hopping off a fishing boat and trying to explain to federal agents that he had missed his court date because he was sick, but apparently not because of COVID-19, which hadn't been alleged to have escaped from a laboratory yet. But for the next few moments, we shall endeavor to discuss the immunity granted to pharmaceutical companies. Not your immunity, but to pharmaceutical companies under the PrEP Act, which is probably just as misunderstood as the immunity that the vaccines are promoted, marketed, or sold to provide. A sale to as many as almost 70% of American happy customers, satisfied customers, without any mandate from the president nor the governor, which should have provided a red flag Notice that a pathogen that has been promoted as highly contagious and lethal would not prompt any government official to mandate vaccines for the sake of public safety. But on all evidence, it did not raise a red flag to most of us. And if you at some point later believe that you had made a mistake, you can expect that the government will tell you that that was your choice, because that's the way that the cookie crumbles in a courtroom. Been there, often on the side of defendants. According to federal authorities at the Department of Health and Human Services, the Public Readiness and Emergency Preparedness Act, PrEP Act, provides immunity to qualified individuals. And a PrEP Act declaration amendments preempt requirements that would result in a qualified person being unable to prescribe, dispense, or administer vaccines as authorized by the state or U.S. territory. While it also provides for a countermeasure injury compensation program for certain individuals who sustain serious injuries or die from receiving the countermeasures. So there is a little fun for some people who have qualified injuries. Moreover, under the PrEP Act, licensing laws that are less restrictive than those in the Declaration Amendments are not preempted, which means in legalese that the federal government will not supersede the decision of a state to administer the COVID-19 vaccines under less restrictions than were authorized under the emergency use authorization at the Food and Drug Administration, and states and U.S. territories are free to determine authorized vaccinators in their jurisdiction. Pretty wide grant about it. While popularly understood as granting an unlimited release, however, from liability to vaccine manufacturers such as Pfizer, Moderna, Johnson & Johnson, and any others that might come along, under the PrEP Act, immunity applies to, now listen up, licensed health professionals. Licensed health professionals authorized to administer covered medical countermeasures under the law of the state where the countermeasure is administered. As a doctor, you are licensed by the state. And other individuals identified in the declaration by the Secretary of Health and Human Services, HHS, so you may have to do some research and reading to find those additional persons to prescribe, dispense, or administer covered countermeasures, including the COVID-19 vaccine. So that grant of immunity, first of all, does not apply to everyone involved in the distribution and administration of the vaccines, since they must be authorized providers under the Act. You find some guy comes up to you and says, "Psst," in a alleyway, he's probably not authorized. So he definitely is not immune. Moreover, under the terms of the PrEP Act, when the Secretary determines that a threat or condition constitutes a present or credible risk of a future public health emergency, the Secretary may issue a PrEP Act declaration. And the declaration provides immunity from liability except for willful misconduct, for claims of loss caused by, arising out of, relating to, or resulting from the administration or use of covered countermeasures to diseases, threats, and conditions identified in the declaration. Okay, going back for just a second. If Governor Northam, like he did with abortion, decides that he wants to authorize that guy in the alleyway to give you a vaccine, he actually can do that. And I don't know that he will, but he just might, given his past history. But the declaration, as we say, provides immunity from liability except for willful misconduct for claims of loss caused by, arising out of, relating to, or resulting from the administration or use of covered countermeasures to diseases, threats, and conditions identified in the declaration. In previous videos, we have discussed some important legal references like at-will employment, disparate treatment, the vaccine as entitlement with a property-like interest, hostile work environment, and the impact of a lack of a government mandate. But under the PrEP Act, the most important provision regarding the immunity that most perceive they have as the pharmaceutical companies enjoy is this provision that states the declaration provides immunity from liability except for willful misconduct for claims of loss caused by, arising out of, relating to, or resulting from the administration or use of covered countermeasures to diseases, threats, and conditions identified in the declaration. Willful misconduct is practically the same everywhere. In practically every jurisdiction means something more than mere negligence, a mistake, like many are claiming to have occurred with a novel coronavirus in a virology lab in China. Like one sociologist with a PhD, Zenep Tufekci, promoted by the New York Times as an opinion writer who has extensively examined the COVID-19 pandemic and apparently has a lot to say about a Dr. Shi. Stated accidents happen, much like Bill Clinton said during my first year in law school in Virginia. Mistakes were made. But this phrase, willful misconduct, in most jurisdictions, communities, places where you have a court, were made to mean also more than gross negligence, a phrase with which some may find familiarity arising from certain information that was found to be not classified at the time, gross negligence, by the same person with the authority to classify it incidentally. No, willful conduct must be knowing and willing, amounting to malicious, and not even just reckless, where a reasonable person should have known better in most instances, will suffice. Willful conduct. And at least for us, these distinctions regarding the culpable state of mind, or mens rea, as is often said in criminal law, are very relevant because we are preparing, not you, but we are preparing an emergency application for a temporary restraining order against the vaccines within the next week in the Richmond Federal Court. But with 1,123,975 adverse events nationwide associated with the vaccines, including 6,267 deaths, 29,964 adverse events in Virginia, including 103 deaths, this may also be important information for you, defining that which may be described as willful misconduct that proximately and directly resulted in actual injury. And there is no genuine issue of material fact that on June 22nd, 2021, Dr. William Petrie, MD, the chair professor of infectious diseases and international health at the University of Virginia, did knowingly and willingly state to reporters at UVA today that getting the vaccine is the single most important protective thing that you can do. That's what he told you. That's what he told you. And with regard to those students and employees on campus, he did also state that the risk is really among unvaccinated individuals. But most importantly, in that interview, Dr. Petrie made some definitive and quantifiable representations, gave you a number to persuade, coax, and encourage persons to get vaccinated and reduce the risks on the UVA campus. He said, data I have seen, his own eyes, from England, which is pre-publication, shows that the Pfizer vaccine was 94% protective against hospitalization. 94%. The AstraZeneca vaccine, which is an adenovirus-based vaccine similar to the Johnson & Johnson vaccine in the U.S., was about 92% protective against hospitalization. And the pharmaceutical companies, along with even the CDC and FDA, which had completed similar studies, one by the CDC that was published on April 2nd, confirming those findings. 95% have been attempting to persuade, coax, and cajole the remaining holdouts to also sign up to make an appointment and volunteer to be vaccinated. And under the law, a state of mind that was aware of some other material fact pertinent to your decision to vaccinate, to risk the adverse events experienced by almost 30,000 Virginians and over 1 million Americans, but that was not disclosed to you, would satisfy the threshold for a willful act, especially under the duty of care owed by a public health professional like a physician with an oath to do no harm. In the Commonwealth of Virginia, common law fraud is defined as a misrepresentation of a material fact known to be false and with the intent to deceive that places the hearer in detrimental reliance. And so just ask yourself the question, or your attorney, if you were placed in detrimental reliance when Dr. Petrie, Governor Northam, the CDC, Pfizer, Moderna, and Johnson & Johnson told you that if you took the vaccine, there was a 95% chance that you could avoid hospitalization if you happened to get infected. Especially since, according to the hospitalization rate for COVID-19, both nationally and in the Commonwealth, that is not any different by any significant degree than if you took no vaccine at all to prevent a validated less than 5% infectious pathogen, not technically infectious, with a 1.8% case fatality rate from infecting you. And almost 70% of Americans rushed ahead and have been administered at least the first dose. Fools rush in where angels fear to tread. This briefing is unclassified, as you will. My name is Major Mike Webb, and by God, I am running for Arlington Public School Board. Let's keep Mike Webb away from our schools. Honest, carry on. This advertisement was authorized by Mike Webb.